The 30th session of the Standing Committee on the Law of Patent just finished with a very positive results. And probably three very salient features of the session are, the first one is the more active involvement of member states in the work of the committee. 250 participants, about 125 patent experts coming from capital. And then you can see the impact of this trend in the quality of the discussions and in the way the issues are addressed. The second element is the more careful attention of participants, all of them as a group, in reaching a balanced agenda. It is clear now that the committee can only progress if the balance is achieved in terms of the agenda items, and everybody is taking care that all those issues of interest for the different regional groups are part of the discussions. And these two elements is what brings the committee again to a very positive result in terms of future work. We have a successful agreement in terms of future work of the committee. And the importance of this is not only that we have an interesting work coming for the next session, but it's particularly about the possibility of discussing those very interesting but complex issues at the multilateral level with the intention to find collectively solutions about how to improve the patent system. So this very positive achievement of the last session is one in row of the last 10 sessions where, again, future work have been agreed upon among member states. So the agenda of the next meeting continue to discuss issues of very particular interest. One is the issue of exceptional limitations. And what the committee have been able to do is to prepare papers, what is called reference documents, that are very dense and precise policy documents on 3 exceptional limitations. And this is only possible because the committee have been able to collect an impressive amount of information that allows the committee to produce documents of the level of those that have been produced and discussed. The second issue is taking into account the increase in the total number of patent applications worldwide, more than 3 million. The committee is looking for solutions about how to improve quality. And among other issues, we have prepared 2 papers, one on inventive step, and particularly inventive step in the area of chemical, in the chemical field, and one on new technologies and how new technologies can impact the work of the different patent offices and how patent offices deal with requests in technologies like artificial intelligence, for example. We continue discussing issues on patents and health. And in particular, we are taking into account the interest expressed by a number of regional groups and how to address issues like the complex issue of patent-related flexibilities and other issues like, for example, the availability of legal status information in available databases, an issue that will continue as an important part of the discussion in the next meeting. And then the issue of transfer of technology, will the committee continue discussing how certain law provisions that are included in different patent law facilitate transfer of technology, and we are going to have an important sharing session on how this is effectively happening worldwide. And finally, on the issue of client attorney privilege, the committee recognized the importance of the subject because there is a change in this area. It's not only attorneys at law or lawyers, the one that represent clients in this area, and if attorneys at law have the possibility of protection of the information exchange with clients through the secrecy obligation, these not always apply to other legal counsel like those that are not attorneys at law. So this reality plus the reality of more international litigation certainly convince the committee of the need to address this issue in the near term. With all those issues, we are convinced next session will be as interesting as the one that just finished now.